Welcome back to the show, viewers. Tonight we're talking about torts in sports, the duties and obligations of organisers that conduct ultra marathons and surf life-saving carnivals and cycling events. The first case we need to go to, guys, which is the leading decision in relation to responsibilities of these organisers and clubs and assumption of risk and things like that, is a case of Wyong Shire Council and Shirt. Do you want to give me the facts of that case, please, Alice?
Look, Tony, this is an interesting case. Mr. Shirt was doing some water skiing in a lake, and he was a little bit of an unexperienced water skier, and he hit his head and sustained some serious injuries when he hit it on the bottom of the lake. And the whole thrust of his case was based on the fact that there was a sign at or near the lake which said deep water, and he had assumed that the water was deep enough all over the lake to ski, when in fact it turned out that there was different sections of the channel and the lake that the sign was referring to.
Now, it's this channel, it was about 900 metres long, was dug out in 1965, 66.
Yep.
Tell us a bit more about that.
Look, the interesting part about this is that there was a sign basically saying deep water, and the plaintiff in this case, Mr. Shirt, thought that the deep water was after the sign.
That's right.
Whereas in essence the deep water was before the sign.
Yeah.
And that's where the confusion about the whole case as came about. And it went all the way to the High Court, and in all instances Mr. Shirt was successful. So
I find it astounding that the council in this case were trying to argue that the sign was not ambiguous, that, it only had one interpretation, and that it was only that they were addressing it to swimmers.
That's right.
Which is really bizarre,
It
isn't
is a bizarre thing.
Basically, it's established, it's a key case in any legal principle now, where it establishes the fact that to be reasonable foreseeable, it's got to be not far-fetched and fanciful, and in this case the court thought it wasn't. Look, I tend to agree, to be honest, because I would have thought when you've got a sign that says deep water, I would have thought it'd be after it. I'd take the same approach.
Oh, look, it's true. You'd look
what do
at
they mean by the words
sign.
far-fetched and fanciful, Alice?
Tony, in this case, the court was at pains to keep reasonable foreseeability, which is a term lawyers throw around a lot, keep it really wide open, and to say that a risk being far-fetched or fanciful really needs to be something that's right out of left field. And just because it's unlikely to occur doesn't mean that it's far-fetched or fanciful. It's more about the proximity arguments and, where is your plaintiff on the day? What is the risk? And is it something that you could reasonably think could happen, even though it may not be?
Okay. On this issue here, the case of Bolton and Stone, an English decision,
Yep.
where a little old lady living across the road from the cricket ground got hit in the head by a cricket ball. The courts in that case found that the case was far-fetched and fanciful.
That's right, Tony. And if you think about it, it's one of those things you might call a fluke, because she's in her backyard across the road from a cricket ground and the ball comes over and hits her on the head, and she was just in the wrong place at the wrong time, and that's what you might call a far-fetched and fanciful risk, because it's not something you could imagine ever happening. Viewers,
it's about a reasonable duty of care, not an absolute duty of care. So the courts won't look at things that are just very mere possibilities.
That's right.
Albeit sometimes you can get up in those circumstances.
That's right, but look, there's got to be something, the occupiers or the organisers have to do something that has put the plaintiff or a person at risk, and there's got to be a positive obligation in that regard.
And Tony, the interesting part about Wyong's case, getting back to Mr. Shirt and his water skiing, was that sign was placed in between the channel and the lake. And so the channel being in front of the sign was deeper than the lake, and Mr. Shirt reasonably assumed that the lake behind the sign was the deep water, because there's the sign in your face in front of the water. So that's certainly what I would have thought.
It's like a speed sign on a road. When it says 40, I assume the 40 is from the sign.
And continuing,
I don't think it's innocuous. I think it's foreseeable, as I said.
I think the council engineer was making a lot of assumptions here that suited himself. Let's get on to the other water skiing case of Roots and Shelton. You know the facts of this too, don't you?
I do, Tony. In this case, it's a little bit more complex. The plaintiff in this case was part of 3 water skiers attached to a single boat. The more sophisticated water skiing boats have a mechanism at the back where you can tow more than one skier. And then the more adventurous among us do like to do a few tricks. And so they do a sort of like an over and under trick where you can cross over the wake behind the boat, and you can go over your friend's rope and under the next friend's rope. In this particular instance, the plaintiff had come across the wake, and then he'd gone right over to one side of behind the boat, and some of the water spray got into his eyes, and he couldn't really see what was happening, and admitted that that meant he might have gone a little bit too far wide, but in any event, by the time he could see and could get himself back across the wake to continue the trick, there was actually a stationary boat coming straight up, and he hit it and was injured. It's a really tragic case.
Why didn't he assume the risk, Nuncio?
Yeah,
that's what the defendant was arguing.
Yeah, they basically said that the plaintiff in this case voluntarily assumed his own risk, and it was found that he didn't for various reasons, because in these type of crossover skiing incidents, there's usually a driver and sometimes an observer.
What you call an observer.
And what the court found was that the driver should have notified the skier that there was an approaching stationary vehicle, and also that an observer would have assisted in where it was going.
Well, didn't the court also say that the driver of the boat got too close to the launch that they hit?
Exactly right.
That's
they got
right.
too close?
That's
Exactly
right. That's right.
And put him in a situation of danger.
Yeah, and basically the court said, the plaintiff did not accept that risk. He accepted the risk of if, he may have fallen off the ski, that happens, but didn't accept the risk of being, I said, pulled closer to a stationary boat where he might suffer injury.
And
just curiously, who has to prove the voluntary assumption of risk argument?
it's always the onus is on the defendant, and there's been a lot of cases in the High Court about this. Tony, the courts are particularly preoccupied with voluntary assumption of risk because it is a complete defence, and if the defendant proves that you voluntarily assumed the risk of getting hurt, then your case is going to fail. And the fact of the matter is it is a high burden of proof to prove, and a lot of the court's discussion revolved around the risk-taking element of water skiing because it is a dangerous sport. But one thing that we haven't mentioned yet is that there are specific signals you can give to a water skier to let them know what's out there. I come from a water skiing town. And so it's one of those things where the factors in this case really told the story, and each case really does turn on its facts in that regard.
Well, in this case, the key elements was the driver was careless.
That's right.
There was no one to observe and to warn the water skier.
That's right.
But also this issue about voluntary assumption of risk, the High Court in 1948 said that the onus of establishing that point falls on the defendant.
That's right.
And they've got to put up sufficient facts to prove that point.
Yeah.
They can't just throw it up and assume that,
Look, it does turn on its facts, as Alice said, and, if you're at a cricket ground and watching the cricket and you get hit by a ball, that's something that you probably assume the risk of. But said if you're hidden away somewhere and things happen and...
Nunc, what do you assume the risk? I mean, let's be realistic. How many people hit sixes that go over the fence and land in someone's front yard? The ground might have been small. These are all important issues.
But if you're in the ground, though, that's where they might say, well, you've assumed that risk. Or say, for instance, you ride a horse and, you fall off.
Equally, or if you get on a motorcycle or you go for a Grand Prix drive. We'll come back to this.
We're going to go to a break. So viewers, please stay tuned. And after the break, we'll go to some of these ultra marathons and cycling events and things like that. So don't go away.